Karen, can you hear us? Okay, Karen, do you have Bucker Brett now?
That's pretty good.
Mr. Files is gonna be getting on upstairs.
Okay,
I'll buzz up there real quick. Okay,
okay.
thank you. Carrie? Tammy? Hey, Denise is asking if Bucker Brett is on yet. On that hearing. I assume Carrie's helping him up there. The cord is on. Huh? Thank you. Tammy's getting them. Thank you. I'm staying downstairs in the first floor conference room, and they're upstairs.
All right, so they're fixing to sign on?
Yes.
All right. Mr. Hernandez, I'm going to put you back in the waiting room until your attorney gets logged on.
Okay, all right,
Stay where you are, though, please.
all right.
I'm sorry. I don't know if they must be having problems up there.
All right, well, I'm going to go on and do some of our other stuff, and I'll check back in just a little bit.
All right.
What if that old boy, he probably got about as much idea what the.
Okay. Are they working on it?
Gary's working on
Hi, Thad Davidson here. Can you hear me?
Yes, but we cannot see you.
Oh, okay.
And then is your client logged in on another one for you?
Yes.
Okay, I can't see that one either.
Okay. I'm looking at Zoom options.
Is your camera closed? Do you have like a little lens over your camera?
No, I can see you guys just fine.
Right, but you would be able to even if your lens is closed.
Hold on a second. I can see the judge. Can you see me?
Nope.
No,
Okay.
we can't see you.
I just
Thad.
sent you a thing asking you to start. There you go.
Okay.
We got you. We got you. You're
Okay.
on.
But
All
I
right.
still do not see your client. And I've sent a message for them to start the video. We'll see.
All right. She's running down the hallway. Okay. Well, no, I see the judge, I see me, and I see Miss Flores.
What's the defendant's name?
Emily Hefner, Judge.
Are y'all in the same building, Thad?
Yeah, we're in the same building. She's just right down the hall.
Well, let's, just for time's sake, just share yours with her.
That's fine. Bring her down here, Amanda. That's no problem. We can do that pretty easily.
Yep. For this top hearing, we can do that.
Just grab a chair, come up behind me.
Why is his picture so little? He must be on a cell phone.
And then okay, she's coming up right behind me. You should be able to see her now.
Okay, I can see Ms. Hefner, Hefner, behind Mr. Davidson.
Yeah. Move over so you can see.
Can she, there, right there, right there, Thad, if you can keep her right where she is now. I can see her.
We're good, Judge.
All right, we're on the record in cause number 2410280-17, State versus Emily Nicole Hefner, present by Zoom. With her attorney by Zoom, Mr. Thad Davidson, State's Counsel, Mr. Zach Davis is present, and the court's probation officer, Marcella, is present. This is on Mr. Davis's motion to terminate deferred adjudicated probation. Electronically filed July the 28th, 2020, 3:12 p.m. You want to go ahead, Mr. Davidson, on your motion to terminate the deferred adjudicated probation. The court takes judicial notice of the file and all the prior proceedings in the case.
All right, Judge. As I wrote in the motion, and as I can prove up through Ms. Hefner if needed be, as well as judicial notice of the file, she's been on deferred probation out of your court for possession of controlled substance penalty group. Penalty group 1, I believe, for 1G, 1 gram, greater than or equal to 1 gram and less than 4 grams. It's a automatic state jail felony case. The court gave her deferred adjudication probation for 5 years, which began on June 5th, 2017. She has done more than half of that. She's completed over 3 years of the 5. She's done all of her community service hours. She's paid her court costs and fees. She's always passed her UA test. She has committed no crimes during her term of deferred adjudication probation. She works at a restaurant. She's attending college. She plans on earning a PhD in chemistry and becoming a research scientist. And of course, I think the court as well, everybody who's in the courtroom knows about the coronavirus and how dangerous it is. It just seems like now would be a good time for her to be released from deferred adjudication so she can go about her life and earn her advanced degrees and start making a real difference in the scientific community.
All right, Mr. Davidson, thank you. Mr. Zach Davis,
Gilmore.
State's position. I'm sorry, Mr. Gilmore, I apologize. I know there's a Zach Davis who is here all the time, as you well know. Go ahead, Mr. Gilmore, it's my mistake, apologize.
Yes, Judge. I was just one correction for the record. Ms. Hefner is on for a 3rd degree felony possession, but everything else is correct. She's done more than half of her probation. She's had no violations. She's done everything asked of her. She's ahead on her. She's completed her community service. The state's going to take no position on this and leave it to the court's discretion on whether to grant the motion.
All right, Marcella, just for the record, in terms for, I don't doubt what Mr. Davidson said, but just for the record, being the court's probation officer, could you just state into the record for me what you see in the records?
Yes, Your Honor. I've supervised Ms. Hefner since she was placed on probation by the court. She's been on probation for 3 years, 2 months. She's completed substance abuse evaluation with Claire Mulford. She's completed outpatient counseling with Claire Mulford. She's completed SMART recovery. She's had no positive UAs. She's maintained full-time employment at Nukes, and she is a student at TJC, and she's compliant, Your Honor. And she's reported as directed each month.
All right, Marcella, thank you very much. Ms. Hefner, I can see you there just behind Mr. Davidson. Of court taking judicial notice of the file, what Mr. Davidson has stated in for the record, as well as what the court's probation officer has stated in for the record. The court certainly finds you have followed, complied with, and successfully completed a minimum 1/2 of your 5 years deferred adjudicated probation. Frankly, it is refreshing to see someone like you who has conducted themselves in a manner that deferred adjudicated probation is designed to work. That is, an individual who's eligible for deferred like you with no prior felonies, who takes all the conditions, takes them seriously, follows all the conditions, passes all your drug tests, does the rehabilitation that was ordered by the court. Obviously, you're continuing on the right path in terms of your education and your goals, what you want to accomplish. Without doubt or further hesitation, the court is going to sign the order which terminates your deferred adjudicated probation this date. And is Marcella, is there anything else you need to go over with her? I'm going to sign.
No, Your Honor, nothing further.
All right, Mr. Hefner, again, best wishes to you. It sounds to me like you're on a course where we won't see in any court anywhere around. And certainly you've conducted yourself in an exemplary manner. You've taken advantage of what deferred adjudicated probation is for, as opposed to other defendants who violate deferred adjudicated probation and end up being terminated and sent for confinement. So the court appreciates the manner in which you conducted yourself. I feel like the rehabilitation has worked in your case, and I certainly find that the motion to terminate deferred adjudicated probation filed by Mr. Davidson is granted, and I have signed the order. Good luck to you.
Thank you, Judge.
Thank you.
Have a nice day.
Anything else, Mr. Davidson?
No, sir. Be safe out there.
Anything else, Mr. Gilmore? All right.
No, Your Honor.
We're in recess. Sign, babe. Are you in North Dakota? You mean you can't hear me yet? Thank you very much. Thank you very much. That completes the picture. Can you hear me?
Yeah, I got this. I got this especially for you. I'm up here in Colorado, and it's the only clothes I got.
Good. I'm glad you've got them on. I was actually going to ask you if you were in North Dakota. So Colorado is close enough. Both your jacket, your cowboy tie, and your hat fit you.
Yeah,
I'd suggest you wear it in East Texas more often.
yeah. I'm in Ouray, and you need to come up here. It's gorgeous up here. Absolutely gorgeous.
Be a long walk for me. I'm not much on airplanes in my age. All right, we're on the record in calls number 24103-64-13, State versus Grant, Tyler Ewing. He's present before the court by Zoom. Mr. Gilmore's present by Zoom. I already noted Mr. Mims, defense counsel's present. Also, the court's probation officer is present. All right, Mr. Mims, looks like it's on your motion for early termination of deferred adjudicated probation. Go ahead on it.
Yes, sir. Brief opening. Mr. Ewing, he's present. We're going to call him in a minute. He's been on deferred probation about 7 years now. And I think he had one hiccup. He had a DWI that's all been resolved. And so we had filed this, I think back in, I don't know, one day last year, and the courts asked us to hold off for 6 months. So we're back. So with that, I would call Grant Ewing.
All right, looks like just for the record, what you referred to there, Mr. Mims, it was filed July the 27th, 2020. So, Mr. Ewing, just raise your right hand to have to swear you in. You solemnly swear the testimony you'll give before the court today will be the truth, the whole truth, nothing but the truth, so help you God.
You got to unmute, Grant.
Got to unmute.
You have to unmute your machine. We can't hear you. May I proceed, Your Honor?
Read the last name.
Got him unmuted?
Yes.
Okay, you solemnly swear and affirm all the testimony you'll give in the cause now on trial today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, Mr. Ewing, Mr. Ewing.
Okay.
Let's see, Mr. Mims, just Denise had just pointed out to me on February the 19th, 2020, on the docket sheet, it's noted case was called, judges continuing defendant on probation announced if the defendant completes another 6 more months without violation, that would be the bottom line, that the court would grant the early termination. That is noted on the docket sheet, Mr. Mims, what you said, so go ahead.
Yes, sir. Okay, call Grant Ewing.
He's sworn and ready to go now.
Okay, all right. Well, state your name, sir.
Yes, sir. I'm Grant Ewing.
And Grant, you are the movant and the defendant in this case, correct?
Yes, sir.
Okay, we have asked the judge to consider terminating your supervision from a deferred adjudication before the expiration of the term, correct?
Yes, sir.
Okay. When were you scheduled to come off of this deferred probation?
It was about another 3 years from now.
Okay, and how long we been on now?
A little over 7 years.
Now, Grant, during that time, have you done everything that you're supposed to do, that you understand that the court is required as a condition of this deferred probation?
Yes, sir.
Well, you did have the one hiccup of the DWI a while back. Is that correct?
Yes, sir.
Okay. We brought that up to the judge back in the first hearing, and you've discharged all your obligations on that, have you not?
Yes, sir.
Okay. Now, Grant, will you tell the judge why you want off early, other than just wanting off early? Is there a good reason that would help society that you believe that you'd like judge to consider to terminate this probation early for you?
Yes, sir. So the main reason why I'm wanting to terminate this probation early is so the fact that I can attend school at a full-time rate, and actually be able to do that. That would be the betterment for me and society as well, just because of the time obligations that come along with the breathalyzer upkeep and probation meetings and random UA tests and so on and so forth. Just having that extra time would be very valuable for me, and to be able to actually go to school, still work, and actually have my own apartment again and everything.
Okay, real briefly, where are you going to go to school? What are you going to study? And where are you working? Just real quick.
Currently, I am going back to Richland College to finish up the last little bit of basics. And then I plan on going to UNT within the next year and a half in order to pursue a degree in computer science so that I can make video games. Lots of math-based stuff, programming, so on and so forth. And then I'm currently working back at Outback Steakhouse, so that way I can actually have a little bit of extra time to work on schoolwork and focus mainly on that while I'm going to work as well.
Okay. All right. Well, with all that, are you asking the court to terminate your deferred probation, not find you guilty, but to go ahead and just terminate the supervision?
Yes, sir.
Okay. Pass witness, Your Honor.
Mr. Gilmore?
Your Honor. Mr. Ewing, Mr. Min said that you had discharged all your obligations for the DWI. Is that correct?
Yes, sir.
Does that mean you received probation for that DWI?
That DWI was finished and sentenced to jail time. This is what we had finished up with in Collin County.
Okay, and you served the time and are now when then continued your felony probation here in Smith County?
Yes, sir.
Okay. No further questions, Your Honor.
Just briefly, Grant, the breathalyzer that's installed on the vehicle, was that done as a court order from our court here, or was that Collin County?
Both, actually.
Okay. Have you got an order terminating that breathalyzer out of Collin County?
As everything was all finished up with Collin County, it was just a pretrial condition is what we had on for that. And so now the only hiccup is just the maintaining it for probation for Smith County.
Okay. And you expect later on to ask Judge to turn me loose of that too?
Yes, please.
Okay. All right, Judge, that's all I have.
Mr. Mims, is that case still up in, where did Mr. Ewing say, was it Denton County, wherever he was on, got the DWI?
That's Collin County.
I'm sorry, all right. Well, is it still so when you're talking about, the other one, that's still, it hadn't been transferred, it's still up in Collin County, correct?
I think he's all he's got to do. I think he's already done all his jail time. He's not under any supervision for them. Yeah, is that right, Graham?
Yes, sir. That's correct.
Okay, I was just, what did Mr. Ewing just mention about needing to finish up? That's why I was asking that. You know what I'm talking about, Mr. Ewing? Or maybe Marcella does. There was something else you mentioned. I don't know what. Go ahead.
Your Honor, as part of his conditions of probation, when the motion was dismissed by the state in the amended terms, he was ordered the ignition interlock, and he still has the ignition interlock. There's no violations.
All right, that clears that up. That's the only question I had. All right, Mr. Ewing, having heard your testimony and what Mr. Mims has had to tell the court along with the state's counsel, I'm going to find all of the goals, certainly in the rehabilitation efforts of the probation department, along with your compliance over this term you've been on the deferred adjudicated probation for, satisfies not only the requirements of the deferred adjudicated probation, but in the court's view, you have basically rehabilitated yourself under the deferred adjudicated probation with the help of other individuals involved. And the court finds it's in the best interest of a society and justice for the court to sign the order terminating your deferred adjudicated probation, which is signed by the court, will be entered in the records today, Mr. Ewing. And the court appreciates your efforts in getting this done the right way, even with the DWO and the other county, you got that squared away. This is the way deferred adjudicated probation is supposed to work, where an individual gets on deferred and then may have had some violation or problem, is continued on the deferred, successfully completes it, successfully follows all the terms. In the court's view, certainly the rehabilitation has been met, and I wish you the best in the future. Appreciate the manner in which you've conducted yourself on the deferred. When you have the DWI, you got it taken care of. So court finds the motion filed by Mr. Mims for early termination should be granted, and Mr. Mims have signed the order terminating the deferred adjudicated probation this date. Good luck to you, Mr. Ewing.
Thank you very much, Your Honor.
Anything else, Mr. Mims? Not on the record, Judge. Well, if you're going to dress like someone in Montana, you need to get in Montana, which I honestly thought you were appearing from Montana. I figured you had an office up there or something. Then I saw your sign, your office behind you. So you fooled me, but not for the whole hearing. So I guess we're done unless you got something else.
Just one minor thing. You know, you got a hog hunt that's waiting on you down there in South Texas. The man that owns the ranch now is a county court law judge of Claiborne County, good friend of mine. So he's waiting to come down there. Okay.
That's good to know, because I came across that certificate the other day and it reminded me I'll be calling you and get the heck down there.
Name's Jaime Carrillo, really good guy, old friend of mine. He is the judge of Claiborne County.
I'm looking forward to it. Probably those hogs look big enough where I might even hit one.
There you go. All right.
All right, Mr. Mims. Thank you.
Thank you, sir. Excused.
All right. Yes, sir.
This next one is a pro se. She's wrote a little affidavit. She's not on yet. Gotta admit her. Is it Albert? You're muted. Hold on. Okay. Can you hear us?
Yes, ma'am.
And you're Miss Heather Holbert?
Yes, ma'am.
All right.
All right. We're on the record in calls number 241-1369-16, State versus Heather Renee Holbert, Hurlburt. Court takes judicial notice of all the prior proceedings, which are going to reflect back on January the 17th. The case was called. Defendant was present with counsel Don Davidson, who had been a court-appointed counsel at that time. Lucas Machek, state's attorney. He's now an assistant United States federal attorney. Mr. Gilmore is representing the state today. The defendant entered a guilty plea, placed on probation, deferred adjudicated probation for 5 years. Of Court calls to order paid restitution due in the amount of, appears to be $7,207 to Texas PHHS. So the court takes judicial notice of all the prior proceedings. Take a little bit further look at the docket sheet. It's like on January the 26th, 2019, defendant entered a plea of true to paragraph 2. Defendant entered a plea of not true to paragraphs 3, 4, 5, and 6. Court finds all paragraphs true. After all testimony, court will, I'm not sure I can read the rest of that, but at any rate, apparently that the court takes judicial notice of those proceedings. The court had apparently conducted a hearing on that date, July the 26th, 2019. Defendant entered a plea of true to paragraph 2, then entered a plea of not true to 3, 4, 5, and 6. Hearing was conducted and the court found the allegations in those paragraphs to be true. So the defendant, just to finish the background, the offense being a theft of property. So the defendant would have obviously still be on. Well, let me ask this question because it's not actually noted on the clerk's written entry on the docket sheets. Mr. Gilmore or Marcellus, do I take it on this? The violations, the ones she pled not true to was found true. And she had pled not true to 3, 4, 5, and 6. The court found them true. And then did the court then continue her on probation? Is that how we got here today, Mr. Gilmore?
Yes, Your Honor.
Yes.
The court continued with amended conditions.
All right, so she was continued on with amended conditions, correct?
Yes, Your Honor.
So Marcella, what's the situation now on, she was continued on probation with amended conditions of probation. That appears to be back on July the 26th, 2019. So we pushed on down a couple of years, close to a couple of, well, let's see, July 26, 2019, up to today. So she's presently obviously still on probation. So, but there's a note here. Apparently Mr. Don Davidson originally represented her. Apparently there's a note here that, do you represent yourself now, Ms. Holbert? H-U-R-L? You represent yourself?
Yes, sir.
Okay, when did Mr. Davidson's representation cease?
His representation ceased after the July hearings from the offenses.
All right, there is okay, let me just look here at the file just a minute. There is a motion for discharge from community supervision and dismissal of case. Appears to have been filed on July the 17th, 2020.
Yes, sir.
Appears to be a statement here in the file from you, a typed statement with your
Yes,
name
sir.
typed on it. There is a note, and Mr. Gilmore, representing the state, maybe you can speak to this. Of course, taking judicial notice of all the prior proceedings, but on the motion for discharge from community supervision and dismissal of calls filed on the date I just read into the record, there's a note on the front of this. My coordinator may be able to help me with this, but there's a note on the front of the motion for discharge from community supervision and dismissal of calls, which says on the note, void, cannot be filed, must be sworn through an attorney. Now, that could have that come from the, I don't, let me hand this to my coordinator because I can only go off what's in the file. Hang on a minute.
That didn't come from me. What are you reading?
Keep going. It's on the doc. It's on the motion right there.
I'm sorry, Your Honor. I'm looking in Odyssey in the scanned motions, and I don't see a note that says that.
Well, you probably because you don't have one. It says that. Do you see it, Denise? It's right there on the. Let me see.
Oh, that's on something else.
Okay, I see that the note is there, but let me see what that note is on. I thought it was on the motion for discharge and community supervision. This motion for discharge from community supervision and dismissal of calls, which is the current one I'm now looking at, August the 7th, 2020, State versus Heather Renee Hurlbert, who is representing herself in a pro se capacity. Mr. Don Davidson apparently no longer represents her.
Judge, I have no idea who wrote that note or what it means.
I don't either. I don't believe I've ever seen a note exactly
But they
like that.
file marked it, so that makes their
They-
note void.
They did file mark it. Well, what we're going on is this one filed, apparently the most recent one's filed August 7th, 2020. You with me on all this, Mr. Gilmore? You see what I'm talking about?
Yes, Your Honor, I do.
Okay, what's the state's position going to be on this? Then I'll hear from Ms. Hurlbert.
The state is going to oppose this motion for early discharge, Your Honor.
Okay, well, then we're going to need to have a hearing. Now, you're sort of in a dual capacity, Ms. Hurlbert. How did you get to the point of representing yourself? What happened to Mr. Davidson?
He would no longer return my phone calls. And I had spoke with a couple other attorneys and was told that I really don't have to have an attorney to file this paperwork for early release, because everything that was ordered to be paid last July when I had my hearings, I've done. I owe nothing else. The only thing I pay is my supervision fees a month. And with the job that I have now, having to worry about travel permits is very difficult because it's oil field. So sometimes it's last minute when I have to leave and go out of town or go out of state, and I can't, it's really hindering me to wait on travel permits to be able to do my job.
Okay, let me step back just a minute before I get into the facts. Need to make a determination here since is there anything is there any order from the court discharging Mr. Davidson, Denise? Okay, well, I will have to sign an order. I mean, if Mr. Davidson is your counsel of record, and apparently this was filed pro se by you, but I'm a little hesitant to proceed on this until I have an order where Mr. Davidson is actually removed by the court as your attorney. That would be the first step. Otherwise, I'm proceeding. You're telling me you're pro se, but the record shows Mr. Davidson is your court-appointed attorney, and I can't go into it in that type situation. And perhaps the state's counsel could help me with this, but I would either have to have a motion to withdraw from the record attorney, Mr. Don Davidson, before I could start hearing this pro se. I can't hear you.
I believe her attorney
Was your attorney Mr. Thad Davidson?
My attorney was Thad Davidson for the hearing in July of 2019. Donald Davidson was my court appointed back in January of 2017 when this case started.
All right, so in that second hearing, you had retained counsel, Mr. Thad Davidson?
I did, yes, but
Okay.
I haven't spoke with him since last July.
Well, here's what I'm going to need to do, and I apologize. I didn't see or noted right off, but my court coordinator did. But at the last hearing, Mr. Thad Davidson, he would have been your retained counsel. I can't take this up without either Mr. Thad Davidson present or without a motion to withdraw filed by Mr. Davidson as your attorney. So I'm not going to be able to go forward on this today because your retained counsel of record, Mr. Thad Davidson, is not present.
Okay.
So the only thing that I can do on this, and I'll get you a reset date from Denise, and I'm going to reset this to this new date. And I think what I'll ask my court coordinator to send an order of setting to Mr. Davidson, since he is still attorney of record, according to what you've told me. And that notice that'll be going to Mr. Davidson will give him the new date for the court to hear this. And I'm going to get a date from my court coordinator. Then we'll go back on by. I just finished a different case by Zoom with Mr. Davidson. So we'll conduct another hearing on this with Mr. Davidson present, unless I have a motion to withdraw from him as representing you.
Okay.
Okay, so you with me on all that, Mr. Gilmore?
I am, Your Honor.
I'm going to reset this case if all of you would make note of it, because I'm getting ready to sign an order resetting this motion for early termination. It's reset to Thursday, September the 17th at 11:15, again by Zoom.
Okay.
All right, so I'll be singing an order of that setting to Mr. Don Davidson.
Okay.
And to state's attorney and to you. I need to be sure that I got an accurate address on you. You don't have to, is the address in the file accurate so you'll get the order?
I'm not sure which address you have on file.
Okay, okay, my court coordinator said you got this notice, so we're good with your address. I'm gonna sign an order resetting this motion for early discharge on Thursday, September the 17th, 11:15 by Zoom. This order will go to Mr. Davidson, your attorney of record, to you, state's counsel, and Marcella, the court's probation officer. Any other questions? Any other questions? Anything else, Mr. Gilmore?
No, Your Honor, not on this matter.
All right, we're in recess to Thursday, September the 17th at 11:15.
Okay.
Better be sure and send her the order to these two. Where we don't end up if they had not heard. What else is that it?
No, but okay, we're ready. We're Frederick. Love it.
This is in cause number 2410637-19, State versus Eric Rodriguez Hernandez, present for the court by Zoom. Mr. Zach Gilmore, representing the state, is present by Zoom. Mr. F.R. Buck Files is present by Zoom. Attorney for Eric Rodriguez Hernandez. On state's first amended motion to adjudicate guilt, file marked May the 27th, 2020. Mr. Files, you want to waive the formal presentation and reading of the state's first amended motion?
Oh my God, he's gone. And now he's completely gone.
There he is.
Hello.
We're here now. I mean, we've been here. Y'all are here.
All right, we've got Mr. Files, I believe, now on Zoom. This is.
I'm trying to get his.
I'm sorry? Oh, I understand all that. Just go ahead and take the time you need.
That's your camera.
That's not it. Buck would quit pushing buttons.
Where we are.
Okay, flip your camera back around, Buck. We're seeing your desk with a pen on it. There you go.
All right, now we got you, Mr. Files.
But we still don't have the gallery view.
The what?
Carrie, look up top. You should see little buttons that lets you change it.
I see Mr. Rodriguez.
Well, I can see about half or 2/3 of your head. There you go, Mr. Files. That's fine. All right, well, here's, looks like on the screen in front of me, I've got the defendant, Eric Hernandez from jail. And I've got Mr. Gilmore representing the state, Mr. Files representing the defendant. It's on the state's first, and the court's probation officer, Marcellus, present by Zoom. It's on the state's first submitted motion to adjudicate guilt. Do you want to waive the reading and formal presentation of that first submitted motion, Mr. Files?
I can't hear the,
Oh, you can't get us? Okay.
I can see and hear the court now. I missed the first part.
Okay, that's okay. I'll just start over. In cause number 24106, 37-19, State versus Eric Rodriguez Hernandez, present before the court from jail by Zoom. His attorney, Mr. F.R. Buck Files, is present by Zoom. State's counsel, Mr. Gilmore, is present by Zoom. The court's probation officer, Marcellus, present by Zoom. Do you want to waive the formal reading and presentation of the state's first amended motion to adjudicate guilt, Mr. Files? I think you must have lost, we've lost.
Yes, Your Honor, all I had was a frozen picture of the court.
Well, you don't want to keep that in front of you very long.
Carrie wanted to put it in her office.
Okay, you want to waive the reading of this motion to adjudicate?
Would you like to walk over?
I don't know. You don't know.
I believe he was frozen again. He may not have heard the court's question.
Technically, what are we doing, Bud?
Ask Buck if he can hear you.
I can't hear you.
Ask Buck if he can hear you.
Mr. Files, can you hear me?
I can hear you now. I could not hear you earlier.
That's what I figured. All right, now that you can hear me, we've got, of course, you, the defendant, present, Marcella, the court's probation officer, present, Zach Gilmore, state's counsel's present. So do you wish to waive the formal presentation of the state's first submitted motion to adjudicate guilt, and is his name correct?
Okay, we're just
Reading of the presentation of the pleading in open court.
All right.
We waive all the formalities which the court permit, including the presentation of the application in open court.
All right, thank you, Mr. Files. Mr. Hernandez, raise your right hand. I have to swear you in. Do you solemnly swear the testimony you'll give in the cause now on trial today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Hernandez, have you been over the state's first submitted motion to adjudicate guilt filed May the 27th, 2020 with Mr. Files, where you understand all the allegations being made in all the paragraphs of the state's first submitted motion to adjudicate guilt, which allege violations of your deferred adjudicated probation?
Yes, sir.
All right, of course, take your judicial notice, obviously, of all the prior proceedings. I have Mr. Hernandez. It's going to go up, it's up on the screen. It's the There's a document, written plea admonishments and stipulations of evidence up on the screen. There's a signature on there signed. Is that your signature on the line above where it says defendant?
Yes, sir.
All right, it's also signed by Mr. Files as your counsel. Now that, I'm going to specifically swear you to States 5. Do you solemnly swear and affirm all the facts and information contained in States Exhibit 5, the written plea admonishments and stipulations of evidence on the screen are true and correct to the best of your information and belief, so help you God?
Yes, sir.
All right, understanding all the allegations filed against you by the state in its first admitted motion to adjudicate guilt, this document now on the screen, States 5, written plea admonishments and stipulations of evidence, gives you the original criminal charge in the indictment, possession of a controlled substance. The maximum sentence possible is up to 20 years in the Texas Department of Corrections Institutional Division and a fine of up to $10,000. Do you understand that?
Yes, sir.
Now, the court takes judicial notice of the prior proceedings in the case. They're going to reflect, as set out in the state's first admitted motion to adjudicate guilt, that you appeared before the court, entered a plea of guilty to the offense of possession of a controlled substance as charged in the indictment on the 16th day of July 2019. The court received your plea of guilty. The court deferred further proceedings without an adjudication of guilt. And on the 16th day of July 2019, you were placed on community supervision on terms assessed by the court. You were placed on community supervision probation for a period of 10 years. And of course, the state has now filed this motion to, now it'll go up on the screen because the state has now filed a motion. It's the state's first admitted motion to adjudicate guilt. It's up on the screen. It has several paragraphs in it. Each one of those paragraphs, enumerated paragraphs, allege violations of your deferred adjudicated probation as set out in paragraph 8, 23, and then under numeral 2. So you've got on the bottom of the first page, 1, commit no offense against the laws of this state or any other state. 5, remain in Smith County. There's conditions in that. 23 has conditions. Roman numeral 2, 3, and 4 have conditions. In this document you signed and sworn to, the written plea admonishments and stipulations of evidence, you tell me under oath, this is what your stipulation says, this portion of it. It says that the defendant has read the foregoing admonishments, that's 1, 2, 3, and 4, as well as the allegations against you as set out in the state's first submitted motion to adjudicate. Then you say in this document that you've now sworn to, understanding the admonishments, that's 1 through 4, and the allegations, those are allegations alleging violations of your deferred adjudicated probation. This document says you make the following free, knowing, intelligent, and voluntary stipulations of evidence. 1, you're obviously the same individual the court placed on deferred adjudicated probation in this cause number. Then under 2, and you can see it on the screen, that you stipulate under oath that the allegations as set out in all the paragraphs of the state's first admitted motion to adjudicate guilt are true, and that you, with your attorney, Mr. Files, present, you are entering pleas of true to all the allegations in the state's motion to adjudicate in paragraphs 1, 2, 3, 4, and 5, which allege violations of your deferred adjudicated probation. Is that correct, Mr. Rodriguez?
Yes, sir.
Are you stipulating and entering those pleas of true to the allegations alleging violations of your deferred adjudicated probation in paragraphs 1, 2, 3, 4, and 5, freely, intelligently, knowingly, and voluntarily?
Yes, sir.
The court receives and accepts your stipulated and entered pleas of true to the allegations contained in States 5, the written plea admonishments stipulations of evidence, of course, paragraphs 1, 2, 3, 4, and 5, to which you stipulated and entered pleas are true, contain allegations of violations of your deferred adjudicated probation. Do you understand all this, Mr. Rodriguez?
Yes, sir.
All right, then, as you sign and swear to this document, States 5 of your own free will, and sign and swear to it voluntarily.
Yes, sir.
And you do solemnly swear now all the facts and information contained in States 5 are true and correct to the best of your information and beliefs. Is that correct?
Yes, sir.
All right, you want to offer states 5?
Yes, Your Honor, we'll offer states
Gilmore?
5 at this time.
Any objection to states 5, the written plea admonishments and stipulations of evidence, Mr. Files?
No objection, the exhibit is marked and offered.
With no objections to the exhibit is marked as offered. States 5, written plea admonishments, stipulations of evidence, signed and sworn to by the defendant, signed by his attorney, is admitted into evidence as states 5. All right, what do you have now with states 5 having been admitted in? Mr. Gilmore?
Your Honor, the state has a
Obviously, I'm sorry, let me take one step back. Court having admitted into evidence states exhibit 5, the court does grant the state's first amended motion to adjudicate guilt, file marked on May the 27th, 2020. Court having granted the state's first amended motion to adjudicate guilt, the court does revoke the probation, deferred adjudicated probation, assess the defendant for possession of a controlled substance on the date reflected by the docket sheet. The court having granted the state's first amended motion to adjudicate guilt based on the violations to which the defendant submitted its guilt under oath, the court does find the defendant guilty of the offense of possession of controlled substance, a second-degree felony, as alleged.
No, I'm not on, all right.
As alleged in the indictment.
Your Honor.
You with us? Are you with us, Mr. Fowles?
I may be getting 1 out of every 4. I want to be there when we're talking about sentencing the case. Can I just come over to the courtroom quickly? I'm not hearing 1 out of every 10 words the court's saying.
Well, I'm speaking right into the mic. There's no telling what the problem is. Just to give you a short capsule, and you can certainly come over to the court. What I've done is simply, I've gone over the motion to, I've gone over the affidavit, the written plea admonishments, stipulation of evidence, the written plea admonishments and stipulations of evidence. I've taken the defendant's stipulated and entered pleas of truth to the allegations set out in paragraphs 1 through 5 in the state's first amended motion to adjudicate guilt. So that's where we are right now. The only other step I would have before sentencing is talked about is that I would go ahead and grant the state's first amended motion to adjudicate, find him guilty of the offense alleged in the indictment, and then we can talk about sentencing. That's where we would be. I'm not sure how much of this you've got. Well, Mr. Fowles, why don't you just come on over here? I'm sorry, but this between you.
Your Honor, I'm missing everything you're saying. Can I just sprint over to the courtroom? I'll be there in 5 minutes.
Yes.
Thank you.
All right, I'm gonna go and do my other stuff. I got other people waiting.
Mr. Hernandez, give us just a minute till he gets here and I'm gonna put you back in the waiting room.
All right.
Yeah.
Let's see, I got.
Mr. Gilmore?
Yes, Your Honor.
You'll need to come on down to court.
I'll be right there.
Well, hang on, I'm gonna get these other 2 people that have been waiting in the waiting room since 1:30 done. real
Okay.
fast.
Okay, we're going to a couple other cases apparently.
Mr. Platten, can you hear us? You're muted.
Okay, let me find that.
I just unmuted you so you can hear me. I can hear you. Mr. Huffstetler, can you hear us?
Yes, ma'am.
All right.
Early termination.
This is in cause. Sorry, I still got Mr. Gilmore by Zoom. This is in cause number 2410356-16, State versus Jonathan Huffstetler. Present before the court on Zoom. His attorney, Mr. Platten, is present by Zoom. Go ahead on your court takes judicial notice of all the prior proceedings in the case. The docket sheet reflects that back on what appears to be June 13, 2016, case was called. Defendant was present with counsel Eric Platten. Lucas Makachek was representing the state. The case was set for a plea deadline and not a plea trial. It's last entry on the docket sheet.
Oh, Judge, it should be an early termination. Hang on. Oh,
Well, I'm just looking at the docket sheet I've got.
no, this is on early termination.
Okay, well, I'll just go move away from the docket sheet. I just read the only entry on the docket sheet, that's okay. Mr. Platten, this is going to be obviously on the state's, this is obviously on Mr. Platten's motion for early termination of community supervision. Electronically filed June the 10th, 2020. Mr. Platten's present. The defendant is present. Mr. Gilmore's present. Go ahead on your motion, Mr. Platten.
Your Honor, he was placed on probation in June of 16. We petitioned the court back June of 19, and at that time we were instructed to come back this year if there weren't any other issues. He's been on probation since that period of time. He's completed more than 2 years. He's satisfactorily complied with all of his conditions, hasn't had any other issues while on probation. And for these reasons, Your Honor, we'd ask that the court consider his motion for early release, Your Honor.
Let's see, he was on, I'm sorry, having a little hard to tell from the docket sheet. Let me just look at your, says this is what your motion has. Jonathan Huffstetler was convicted of theft of a firearm June 27, 2016. Sentence was suspended. Defendant was placed on community supervision for a period of 5 years on June the 27th, 2016. So then there's some other recitations of the motion for early termination from counsel. So how far are we into it? You've apparently already figured it. He went on June the 27th, 2016. I don't know the date. I'm sure it's in the docket sheet when you were asked to come back on a subsequent date. How long has he been on as of today, Mr. Huffstetler and Mr. Gilmore, if y'all can agree on that?
Your Honor, by my calculations, I think it's 4 years and 2 months, give or take some days.
Is that you, Mr. Gilmore?
Yes, Your Honor, that by my calculations, that's how long Mr. Huffstetler has been on probation.
All right, he was placed on community supervision for 5 years on June the 27th, 2016. So now he's up close to the 5 years. Is that correct?
Yes, Your Honor, I think about 8 months away.
All right, now go ahead on your, anything else on your motion you've got. I get the record, Marcella, I take it the record would reflect that other than, have there been any, have there been any violations anywhere along the line?
Yes, Your Honor, there's been allegations of consumption of alcohol, and a motion to revoke was filed, and the state withdrew with amended conditions.
And that's something that we addressed last year at this time, Your Honor. And the court informed us that they didn't have any other problems by this time of this year, like we're sitting here right now, that you'd allow them to get off probation.
Well, it would appear to the court, the end counsel, Mr. Gilmore and Mr. Platten, that we're up now to that date that was just put in the record, close to the full 5 years. So apparently from the time he came in last time, Marcella, where he had a violation, and the court did not grant the motion for early termination, apparently at that time, and asked Mr. Platten to refile it later. And now the defendants, since the first violation, have there been any others, Marcella?
No, Your Honor, he's in compliance.
All right, we're up now just short of the full 5 years. So what's the state's position, to give you an opportunity to speak on that one, Mr. Gilmore?
Your Honor, the state's going to take no position on this one.
Okay. I mean, when you don't take it, you certainly have a right to take no position, but when you take no position, maybe I'm missing something. Is there some, and he was in earlier, at an earlier date, reflected on the document. I did not grant the early termination, asked Mr. Platten to come back later. Then the defendant has had, Marcel, to be sure I've got this right. I've got this right. Since he was in the first time on a motion for early termination, between then and now, there have been no further violations. Is that correct?
That is correct. He's submitted to UAs. He's completed his jail time. He's completed intensive supervision. He's current on his financial obligations. Your Honor, he's in compliance.
Considering how close the defendant is now to completing the full 5-year deferred, and apparently he has done what the court asked him to do last time. I did not grant the motion for earlier termination earlier. I kept him on deferred. There's been no further trial. Best I'm doing, I'm just going to get to the bottom line because of all everyone's you know, I don't even know where it's coming from, but I was having a hard time hearing, so I'm going to go ahead and based on what the record reflects, I'm going to grant the motion for early termination of community supervision this date. I've signed the order. Good luck to you, Mr. Costello.
Thank you very much, Your Honor.
You're welcome. In recess on that case. What do you want to go on the back on the record on your
Yes,
issue?
I've got one more. No, you're good. It's just Zach's got to come down here and I want to get Zoom done because it's been a night.
Your fault, not our fault.
Where's it, Chavez?
Zoom's like a little girl with a in the middle of her forehead. When it's good, it's very, very good, and when it's bad, it's hard.
A lot of things have changed since I first met you, which is an old story.
They're gonna think.
Okay, I got to talk to Mr. Files, I apologize. We're going on the record in calls number 24105-87-17, State versus Vincent Michael Chavez, present from, is he in jail? I don't know.
No, he
All
said
right,
his
defendant's
attorney's
out
on.
on bond, apparently. His attorney, Mr. Don Davis, is present on Zoom.
No, it's Miss Porter. She filed the motion.
All right, well, the docket sheet reflected Don Davis, and apparently looking up, I see Miss Porter, Madeline Porter, and then State's Council's present. So this is going to be on Ms. Porter's motion in 241-0587-17, State versus Vincent Chavez. Motion for early termination. Go ahead on it, if you would, Ms. Porter.
Yes, Your Honor. I filed a motion for early termination. I'm sorry.
Miss Porter, you and your client are too close to each other.
Okay.
That's.
Is that better?
We'll
Yes.
see.
Okay. I apologize. I filed this motion for early termination.
No, you're gonna need to be in it's still background.
It's bouncing around.
Okay. How about this? Is that better?
All right, the court in this cause number 24105-87-17. State versus Vincent Chavez, present by Zoom. His attorney, Ms. Porter, present by Zoom. Mr. Gilmore is present by Zoom. This is on motion for early termination filed by Ms. Porter. Go ahead on your motion, Ms. Porter.
Yes, Your Honor. We filed this motion for early termination based on the fact that Mr. Chavez was placed on 5 years deferred back on July 24th of 2017. And as of today, he's completed 3 years, 1 month, and 8 days of that 5-year term. I believe he is in compliance with all of his terms and basically just needs to continue to report and have, clean drug tests for the remainder of his probation term before, he would normally be terminated with his probation term. But we're asking that since he's in compliance, he be allowed to have that probation terminated early. And I believe that the state is taking no position.
Mr. Gilmore, what's state's position?
Your Honor, the state's going to take no position on this matter. I do think there might be a couple of things we need to clear up with probation, though.
Go ahead, Marcella. What you want to, Marcella, just raise your right hand. You can just testify. Solemnly swear the testimony you'll give before the court will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, Your Honor.
All right, go ahead, Mr. Gilmore. Marcella's under oath.
Now, when the defendant was on, when Mr. Chavez was on probation, there was an issue with him consuming alcohol, is that correct?
That is correct.
Okay, but the way probation found out, well, how did probation find out about the alcohol consumption?
He reported to his officer March 27 that he drank 2 shots of vodka for his birthday on January the 12th of 2018. And the reason he told the officer 2 months after because it was on his conscience. So he informed the officer.
He volunteered the information himself.
Yes, correct.
And what was done after that?
A violation report was submitted to the court. Motion to revoke was filed with the court. Education program within 6 months. The victim impact class within 9 months, and intensive supervision. And all his UAs have been negative since then. And he has now paid all his fees to the probation department.
Okay, so he is current now. Currently, he's current on everything.
Yes.
Okay. No further questions, Your Honor.
All right, Mr. Gilmore, what's the state's position?
The state's going to take no position on this, Your Honor, and leave it to the discretion of the court.
Well, they always come down to the discretion of the court with the state taking no position. If I've got it straight, the defendant basically self-reported the consumption of a couple of drinks or shots, whatever you want to call it, of vodka back up. Did you say that back on his birthday? Is that your testimony, Marcel?
Yes, Your Honor.
Did I hear that correct? All right, then that was used on an original motion to adjudicate. The warrant went out. He was taken into custody. There was a hearing on that original motion to adjudicate. The state then withdrew it, as sometimes happens, and then there was an agreed set of new conditions, and the state agreed to continue him on the deferred adjudicated probation. He's continued on the deferred adjudicated probation, met all the terms and conditions, and there have been no further violations. Is that correct?
Yes, Your Honor.
And now we're down to how much of the 5? How much now at this point? How much of the 5 deferred has he done, Marcel?
Your Honor, he is scheduled to get off probation. Let me see.
Your Honor, I believe he served just over 3 years and 1 month of his probation.
Yes, Your Honor.
He's done just over 3 years of the 5, correct?
Yes, Your Honor, that's correct.
Considering all of the manner in which the violation was self-reported by the defendant, then the fact the state's filed the motion to adjudicate, it was withdrawn. State agreed rather than going forward on that motion to allow him to continue on deferred adjudicated probation with additional terms and conditions, which the defendant, the record of fact, has completed all the original conditions of probation, as well as the new ones added by the state when they withdrew their original motion to adjudicate. So therefore, the court, considering the whole record, the court is going to grant and is granting the defendant's motion for terminating deferred adjudicated probation. The order terminating deferred adjudicated probation is signed this date. It'll be file marked into the record. Mr. Chavez, hope you can just continue in the manner you're going, and I wouldn't expect to see you again. Do you have any questions for the court?
No, sir.
Anything else, Ms. Porter?
No, Your Honor.
We're in recess.
Thank you, Your Honor.
Yes, ma'am. Thank you, Mr. Gilmore.
Thank you, Your Honor. I think I'm coming down to court to handle the revocation with Mr. Files.
Okay. See you in a minute.
Brett and I did a sentencing proceeding in the United States District Court for the Eastern District of Missouri by Zoom. It went perfectly. I realized there was a possibility that this may stay.
We actually do a lot of them that go smooth. Really, the only problem we have is technical hearing. Anyway,
My
I
concern,
probably should put a mask on since you're here in person.
uh,
I'm over 6 feet. Am I safe?
more than 6 feet apart.
I'm about 10 feet.
Oh, my concern is confrontation.
Is what?
Confrontation. You really think you can cross-examine somebody as good on Zoom? as
Of
you
course
could
not.
if they were
Of
sitting up
course
there?
not. Of course not. You can't cross and examine it. Why would? Of course not. Absolutely not. You can't confront and cross-examine as it should be done on Zoom.
Mike Gibson, a great lawyer up in Dallas. Bruce and Peyton Gibson got started in the 60s, late 60s, and Gibson and I have sent cases to each other. He had something in federal court the other day. He just came back mumbling because, how can you be effective in the courtroom?
Well, let me ask you this, just envision this, because I've envisioned it. Let's say that the ban on no jury trial before, right now, October 1st, or was September 1st. Let's just say we can go back to jury trials in October.
Yeah.
Okay, so I'm gonna go to Harvey Hall, where I'll meet the panel sitting 6 feet apart with masks on. I'll qualify them, and then the lawyers will be out there because they have to select the 12 out there. The 12 come down here. So then they get sworn in, sitting 3 of them in there and 9 of them out there. That's it for the courtroom. It's full. So you're sitting there with your client, Gilmore sitting over there. We have a trial. The witnesses are wearing masks. I understand they now have see-through masks, but we have jurors sitting on, and it's not as, but it's, we got jurors sitting at the rear of the courtroom, back row, trying to judge the credibility of witnesses, which are even with a clear mask. We got all 12 jurors in different locations. I thought the reason we had a jury box was so that all, this is just maybe something I misunderstood, but I thought, at least when I was the district attorney, we had a jury box so that all 12 jurors basically will have the same view and hearing perception of the witness. So perhaps one at the back wouldn't be asking one at the front, what'd he say? Later in the jury room. I mean, that's why I thought that's one of the reasons we have a jury box. That all falls apart if we were required, we're not required, but if we do start trials under the 6 foot distancing with witnesses up here with a face mask on. And I don't think you or I, either one, having been in a few over in a few trials, can really visualize what that would be.
Oh, I have some news for whatever it's worth. When Larry McDougal came in as state bar president, he appointed a super committee with Alfonso out of Gregg County and Kenneth Culpepper, who's the DA up in Roswell, as the chair of the committee. The reason is that the Supreme Court, who's making decisions on civil and criminal cases, had virtually no input from criminal lawyers and criminal judges.
Well, that's good.
They have been meeting aggressively and regularly. They finished up their report and have filed it with the Office of Court Administration. I don't know exactly what they're suggesting or not suggesting, but at least the criminal law judges and lawyers are going to have some input into what the Supreme Court makes decisions.
Well, I hope so, because Kerry gave me a rundown. There was some room right now. I've got Mr. Gilmore, State's Attorney, Defense Attorney, Mr. Files, and I have by Zoom before the court, I believe it to be the defendant in this case, Vincent Chavez.
No.
Is that you, Mr.?
You've got, that's still the old
I'm
file.
sorry, but
It's that one. And I don't know how he's going to hear them talk.
in cause number 2410637-19, State versus Eric Hernandez Rodriguez. He is present by Zoom. His attorney, Mr. Buck Files, is sitting in person in the 241st District Courtroom. Marcella, the court's probation officer, is present in the courtroom. Mr. Gilmore, State's Attorney, is present in the courtroom. Counsel, let's see, how far did we get on this one?
Your Honor, I believe you had addressed with the defendant the fact that he had pled true to all 4 paragraphs in the state's motion. You had yet to, I think, find them true, adjudicate the probation, and then we were to move on to sentencing.
Hang on just a second. Mr. Hernandez, did you hear anything the state's attorney just said?
Yes, ma'am.
Okay. Guess he can't hear.
It might help. Let me try.
All right, so State's Exhibit 5, which is the written plea admonishments and stipulations of evidence. It's signed Eric. Looks like it's, I suppose that's Eric Hernandez. Can you see that one, Mr. Hernandez? I'm not sure it's up, but I need to be sure this is your signature.
Yes, sir.
Okay, so you signed, and to be sure, we went back and forth a little bit, but do you solemnly swear and affirm all the facts and information contained in the written plea admonishments and stipulations of evidence signed and now sworn to by you is sworn to by you freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right. Now, and you did go over those written plea admonishments and stipulations of evidence that are up on the screen with Mr. Files. So you understand in those written plea admonishments and stipulations of evidence, you had an original criminal charge of possession of controlled substance. The maximum sentence possible was 20,
Yes, sir.
20 years in the Texas Department of 20 years in the Texas Department of Corrections Institutional Division, fine of up to $10,000. You understand that?
Yes, sir.
Okay, I'm going to recap a little bit for the record. You understand that the state had filed its first amended motion to adjudicate guilt on May the 27th, 2020. The state alleged in the paragraphs on the second page, and they set out paragraph 1, they set out paragraph 5 and 23. Then they allege violations of your probation by you in paragraphs 2, 3, and 4. Do you understand that?
Yes, sir.
All right, now the written plea admonishments and stipulations of evidence that was up on the screen will be going back up there. There's a signature on the line above where it says defendant. Is that your signature? It's right there. You see it?
Yes, sir.
Is that your signature?
Yes, sir, it is.
All right, now I just gave you an oath. Now you've got it right in front of you. Do you solemnly swear and affirm all the facts and information contained in the written plea admonishments and stipulations of evidence are true and correct to the best of your information and beliefs to help you God?
Yes, sir.
All right, it's now signed and sworn to by you. And it's also signed by your attorney, Mr. Files. And now it shows you were sworn to it by the court. Now, do you understand the written plea admonishments and stipulations of evidence signed and sworn to by you? It has four admonishments at the top, which you understand. And then in the second part, you state in that second part that you understand the foregoing admonishments 1 through 4, and that you also understand all the allegations being made against you by the state in the state's first amended motion to adjudicate guilt. Do you understand those allegations which allege violations of your deferred adjudicated probation?
Yes, sir.
And then further, this document states 5, the written plea admonishments, stipulations of evidence. In the second paragraph, down in the second paragraph, do you see on the document where it says acknowledging the foregoing? It says acknowledging the foregoing, you and your attorney do state that you fully understand and have read the foregoing admonishments. That's 1 through 4. And Mr. Files is sitting here in person. And that you understand all the allegations being made against you in this case as set out in the state's first amended motion to adjudicate, those allegations in the first amended motion alleging violations of your deferred adjudicated probation. Do you understand those allegations?
Yes, sir.
All right, and then when you come down further in State's Exhibit 5, you'll see where you say in this document you signed and I've sworn to you, I've sworn you, place you under oath. You say understanding the admonishments, that's 1 through 4 above, and the allegations being made against you in the state's first amended motion to adjudicate guilt, which allege violations of your deferred adjudication probation. You say under 2 that the allegations as set out in all the paragraphs above of the state's application are true, and you, join with your attorney, are entering pleas of true to the allegations made against you for violations of your deferred adjudicated probation as set out in paragraphs 1, 2, 3, 4, and 5 of the state's first amended motion to adjudicate guilt. Is that correct?
Yes, sir.
All right. In this document, states 5, you do solemnly swear to affirm all the facts and information contained therein are true and correct to the best of your information beliefs to help you God. Correct?
Yes, sir.
All right. You want to offer states 5. That's the written plea admonishments and stipulations of evidence, Mr. Gilmore.
Yes, Your Honor, the state will offer states 5.
No objection to the exhibits as marked and offered.
With no objection, states 5, written plea admonishments, stipulations of evidence is admitted into evidence without objection. The court having admitted into evidence State's Exhibit 5, the written plea admonishments and stipulations of evidence containing the defendant's stipulated and entered pleas of true to the allegations in the state's first amended motion to adjudicate in paragraphs 1, 2, 3, 4, and 5. The court does grant the state's first amended motion to adjudicate guilt. The court does find the defendant guilty of the offense alleged against him by the state in its indictment. The indictment charging the offense of possession of a controlled substance, a felony as alleged in the indictment. The court having found the allegations of the state's first amended motion to adjudicate guilt to be true, the court having granted the state's first amended motion to adjudicate guilt, the court does find the defendant of the offense alleged in the indictment, possession of a controlled substance, a state jail felony. I'm sorry. Possession of a controlled substance, more than a gram, less than, I'm going to read it into the record so this is clear. The indictment charges as a defendant on or about the 7th day of February 2019, anterior to the presentment of the indictment, the County of Smith, the State of Texas, Eric Hernandez Rodriguez did then and there intentionally and knowingly possess a controlled substance, namely methamphetamine, in an amount of 4 grams or more, but less than 200 grams. I've now found based on the defendant's stipulated and entered pleas are true that all the allegations in the state's first amended motion to adjudicate guilt are true. I have granted the state's first amended motion to adjudicate guilt. I'm finding the defendant guilty of the offense of possession of a controlled substance as alleged in the indictment.
Yes, Your Honor, being a second-degree felony with a punishment range of 2 to 20 years, I believe we have an agreed recommendation before the court of 10 years in the Texas Department of Corrections, Your Honor.
Now, can I speak to that and give the court a little bit of background?
Yes, go ahead, Mr.
This is one of those cases where our client came to the United States in an early age. He is far more American than he is Mexican, but he got deported, went down there, surprised, he's got a wife, he's got children, he had a job, and he tried to come back to those. He was captured by federal authorities. He entered a plea of guilty and spent 10 months in Big Spring on illegal reentry. If you are deported and you do not have the permission of the Attorney General of the United States or his deputy designated, it's a federal criminal offense to come back. Should he come back again, his punishment range would be dramatically higher in the federal system than it was this last time. The first time the court heard this, the things did not go smoothly. Visited with Heath about this, and Heath agreed that if we came in today on a agreed recommendation and everything went smoothly, the state would recommend 10 years probation. Excuse me, 10 years confinement in the Texas Department of Criminal Justice.
I thought that's what statutory said.
Now, one additional thing. My client, like every client in the world, wants to know how long am I going to be in the penitentiary before I get out.
I'm often asked that question.
But what we did find out, and how many days credit do we get? How much time credit do I get for time here? We checked with the sheriff's office. he's got 296 days credit for time served as of today.
Okay.
So if the court will follow our agreement of 10 years in custody with a finding of 296 days credit for time served, that's all we can ask.
All right, the court in this, anything else, Mr. Gilmore?
Not from the state, Your Honor.
Court in the case then, based on the defendants who is present by Zoom, based on the defendant stipulating and entered pleas of true to the allegations in the, I apologize, the court in this case takes judicial notice of the full record in the case, which would reflect that the defendant earlier entered a plea of guilt to the offense charged in the indictment. The court withheld the finding of guilt, placed him on deferred adjudicated probation. The state has now come in and filed its first amended motion to adjudicate guilt. The court finding the allegations in the state's first amended motion to adjudicate to be true based on State's Exhibit 5, containing the defendant's stipulated and entered pleas of true to the allegations in the state's first amended motion to adjudicate guilt. The court having found the allegations true, the court grants the state's first amended motion to adjudicate guilt. The court adjudicates guilt. The court finds the defendant Eric Hernandez Rodriguez guilty of the offense of possession of a controlled substance as alleged in the indictment and cause number 2410637-19. The court follows the plea agreement and the recommendation of the state on this adjudication, finding the defendant guilty of the offense charged in the indictment. The court assesses the sentence at 10 years in the Texas Department of Corrections Institutional Division. No fines assessed, court costs are ordered paid. Restitution would still be ordered, Department of Public Safety, if it hadn't been paid in the amount of $180 for the lab fee. Sentence is.
Sorry, Judge, just to be sure that's on the record, probation is informing that he does still have $170 for DPS.
The $170 is still ordered as a condition of the 10-year sentence. Sentence is formally pronounced by the court. Court having found the defendant guilty of the offense alleged in the indictment. Court having received and accepted the defendant's plea of true to the allegations in the state's first amendment motion to adjudicate. Court formally pronounces sentence. Court finds the defendant guilty of the offense alleged in the indictment and cause number 2410637-19. Court assesses the sentence at 10 years in the Texas Department of Corrections Institutional Division with credit for time served, just dictated into the record by Mr. Files. I believe it's 294 days. What was it?
296.
296. Court assesses credit for time served at 296 days. Sentence is any legal reason for formal sentencing, Mr.
No legal excuse to offer why sentence should not be now pronounced.
The court then formally pronounces sentence. Court does find the defendant guilty of the offense of possession of a controlled substance as alleged in the indictment. Court follows the recommendation of the state. The plea agreement assesses the sentence at 10 years in the Texas Department of Corrections Institutional Division. No fines assessed, court costs are ordered paid. Restitution is ordered Department of Public Safety and the amount still due for the lab fee analysis. Credit for time served granted on the sentence in the amount of 296 days. The court has a waiver of right to appeal. Mr. Rodriguez, your waiver of your right to appeal, there's a trial court certification of your rights to appeal. It's X where it says you have waived your right to appeal. Waive, of course, meaning giving up. So are you presenting now your waiver of appeal signed by you and Mr. Files?
We are, Your Honor.
Thank you, Mr. Files. Court receives and accepts a waiver of appeal. Be the order of the court now that the defendant is continued to the custody of the sheriff until he can be transported to the Texas Department of Corrections Institutional Division to serve the 10-year sentence assessed by the court for the offense charged in the indictment. The 10-year sentence being assessed with credit for time served, amounting to and calculated as 296 days. Waiver of appeal is accepted. Waiver of motion for new trial is accepted. Anything else, counsel?
Not from the state, Your Honor.
Anything else, Mr. Files?
No, Your Honor.
All right, we're in recess. Defendants continue to custody of the sheriff. They can be transported to the Texas Department of Corrections Institutional Division, serve the 10-year sentence with the credit for time served dictated into the record by the court. We're in recess. It's done.